Nice lady who has made quite a turnaround and sounds so very contrite until you realize that she was driving drunk with a .269 blood alcohol
content, and that this is fifth OWI at just 33, and she's already talking about being creative with sentencing folks. Do you think the judge is buying this redemption arc, or is jail time unavoidable?
Content, and that this is her fifth conviction for drunk driving at age 33. The defendant's character witness sings her praises. Her attorney sings her praises. Hell, even Judge Mogen sings her praises. Is all that enough to keep the defendant's can out of the can?
Here's the twister. Blood alcohol level was 269. That's more than 3 times the legal limit. In legal terms, that's not just drunk. That's practically a walking DUI billboard.
Oh, nerds.
We will go on the record in the matter 23 CF 55, State of Wisconsin versus Sarah Stady. The state appears through District Attorney Kevin Schmidt in person. We have Sarah Stady in person in custody with counsel Daniel Chapman.
Judge Mogen is hearing her fifth OWI plea. Quick poll. If you were the judge, would you give her another chance, or is 5 times just too many? Drop your verdict in the comments.
We're set here today for a plea and sentencing. The parties have reached an agreement. Mr. Chapman, can you please recite the agreement for the record?
Judge, Ms. Stady will be pleading guilty to the 5th offense OWI charged in the information. The state has agreed to recommend the presumptive minimum 18 months initial confinement, and there is no particular agreement on extended supervision. The state has agreed that Ms. Stady and I can argue for less under the benefit to the community exception under 346.65. But that is the agreement, Judge.
All righty. Okay. And Ms. Stady, that is the agreement that you've reached with the state?
Yes.
And that is your understanding?
Yes, Your Honor.
So I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
Yes,
Did your attorney go over this document with you?
he did, Your Honor.
Did he go over it with you thoroughly?
Yes.
That is, did he essentially read it word for word?
Yes.
And so you understand everything completely.
Yes.
Now, is that your signature on the second page?
It is, Your Honor.
If you had any questions with regards to something on this document, did you ask your attorney
Yes.
and he explained it to you?
Correct.
So you're pleading guilty to 1 count OWI 5th. You are 33 years old. You have 12 plus years of schooling. You can read, write, and you understand the English language. You are not receiving any mental illness or disorder, or you don't have a mental illness or disorder. And you have not had any alcohol, drugs, or medications in the last 24 hours. Is that correct?
Correct, Your Honor.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did he go over with you the mandatory minimum as well as the maximum possible penalties that you could face?
He did.
All right. Now, because you're charged with crimes, you are entitled to constitutional rights. And each of those rights is listed on this document. And I'm going to go over those rights with you because this is a mandatory prison case. And I need to make sure that you thoroughly understand those rights. Do you understand that you would have the right to a trial? You would have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have a jury trial in which 12 of your peers would need to reach a unanimous verdict to a guilty plea, and you would, or not guilty, and you would have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights that you would be giving up?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Correct. Yes.
Do you understand, with regards to this matter, this OWI 5th that you are pleading guilty to, the state would have to prove on or around March 4th, 2023, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
Yes.
You understand that the maximum possible penalty here would be up to a $25,000 fine or up to 10 years of incarceration or both. Do you understand that?
Yes.
Do you also understand that there's a mandatory minimum of incarceration? The state or the court must order a minimum of at least 18 months of incarceration. Do you understand that?
Correct.
And do you understand that pursuant to, as your attorney stated, 346.65 paren 2 paren AM 5, that you could argue to the court for a lesser sentence based upon whether or not the community would be harmed and et cetera. Do you understand that?
Yes, Your Honor.
But do you understand the court does not need to follow any of that argument? You understand that?
Yes.
All right. Now, did you go over the criminal complaint with your attorney?
I believe so.
And in particular, there is a section called the probable cause section. You remember that?
It's been a while since we went over that.
All right. So he's showing you the criminal complaint right now, in which it does go over what happened that day and why you were charged with these crimes. All right?
Yep.
And so you see that right now. So now, does that refresh your recollection?
Yes.
And for the most part, are those facts accurate?
Yes.
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of an intoxicant?
Yes.
And this would be your 5th offense.
Yes.
You're pleading guilty to a felony. Do you understand that you would no longer be able to use or possess a firearm for life?
Yes.
No longer able to vote in any civil election until your or any election until your civil rights are restored?
Yes, Your Honor.
Do you have any questions, at least right now, before I begin and take your plea?
No, I do not, Your Honor.
All right, then as to count 1, OWI 5th, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea is done freely, intelligently, and voluntarily. It will find that you understand your constitutional rights and what it means to give up your rights. It will find a factual basis to accept your plea of guilt. Based upon that, I'm going to find you guilty of OWI 5. Count 2 will be dismissed and read in. Count 3 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Before I go to arguments, Ms. Stady, you have somebody who would like to make a character statement on your behalf. Is that correct?
Correct, Your Honor.
All right. Her name is Jennifer Donaldson. Ms. Donaldson, can you please tell me who you are, your relationship, need to know.
Thank you, Your Honor. My name is Jennifer Donaldson, and I am the owner of Empowered Treatment Center in Rochester, Minnesota, also a woman in long-term recovery. I know Sarah through her significant other, Mike Benjamin, and we have been actively involved in this with her since going forward. We were the ones that did the chemical dependency assessment when she was in Olmsted County's custody. And once we do the assessment, we start with them recommendations, we start acting immediately to be able to help and provide whatever services that client needs. At that point, we reached out to a Minnesota Adult and Teen Challenge, which is a short-term program and eventually turns into a long-term program where it can be anywhere from 13 to 14 months long, where they basically are retraining your brain. We discussed it with her, Mr. Benjamin, and my husband as well, who's also in long-term recovery. And it would be a phenomenal program for her to kind of rebuild back her life, but also get some treatment to see what triggered her 10 years ago. And kind of work towards the goals of rebuilding the relationship with her children and having a successful life and being a benefit to the community. And being a stable citizen and figuring out what that problem is because obviously, as you're probably aware, and you see a lot of these cases, any kind of addict, it is a DSM-5. It is just like if you had diabetes or cancer. It is a disease. And that is one of the things why I left my corporate America job to get into this industry, is to help people like Sarah. I will tell you, there's very few people that I actually take time away to speak on their behalf in a court of law when we realize there's 100% in on being able to come up with a solution and what they need to do and how they would need to change and live a full life for recovery. We're there 110%. Sarah has proven that to me and my husband, that that's what she wants. We've had many conversations while she's been in custody.
Risk, her friend, paints a heartfelt picture support system's kids at home, the promise of redemption. But remember, in Wisconsin, even the best character witness can't erase a mandatory 18-month minimum.
I have essentially mentored her. I've worked with a lot of women on that over the past 16 plus years of my recovery journey. And I've worked with a lot of women. And, she's not BSing me on this. I can pretty much read that when someone is, when a client is, and when a client isn't. She's done a lot through her life. And what I'm struggling with, and I understand Minnesota and Wisconsin laws are different. What I'm struggling with is she was doing great for 10 years. Something triggered this. We need to find out what triggered it and what's going on with it. And I believe everyone also has to pay for their crime that they've done. And at the same point, what can we do to help prevent that? And yes, time served. I have 3 DUIs. I sat in jail. I sat in custody. But at the same point, sending someone away for 18 months when she's got 2 young children at home and a phenomenal support system, I don't think is going to help the recovery. I've seen both ways where incarceration has helped. I've seen where people have done the long-term teen challenge program where it's done amazing things. My husband is a graduate. And I'm a single mom too, and it breaks my heart to see what she's done. And I know that she has remorse for it. I know that she wants to better herself. I mean, she's talked to me about trying to figure out a way how to give back to the community with people in recovery. She's like, if I have to do this, Jen, that's fine. She goes, I'm going to better myself. I'm going to do what I need to do. And she goes, when I get out, if I can be back in the recovery community, she goes, can I come work for you? That spoke volumes to me, because I will tell you, getting in this industry, in this field, you have to have a heart and passion and a soul for it, which I think she does. She wants to be able to tell her story. I think there's better ways of making more people realize that, going down this path isn't the right way. And it's just, Sarah has it in her. She has a fire in her to overcome this. And I would just like to be able to give her the opportunity to not spend as much time behind bars as what the 18-month mandatory. If I would plead with you to see how creative we can get with this and be able to do something, because I do believe she'd be a huge benefit to the community. Just the fact she wants to tell her story. A lot of people don't do that. A lot of addicts don't do that. And it just isn't right. And I'll be honest with you. I had a brother that died from a drunk driver. So it's hard for me to speak on behalf of people that drink and drive, but I did it myself. She does feel remorse. She knows what she could have done. And I've been pretty hard with her. And I don't know. If there's anything we can do to get creative with this, I know she would give back, and I know she would do such amazing things for the recovery community. And I'm sorry, with the epidemic that's going on with addiction, we need people like her telling her story that could potentially change someone else's life. I mean, if she touches one person, that's all that matters. It's makes a huge difference. It really does.
Thank you, Ms. Donaldson. All right, now I'm going to turn to Mr. Schmidt for your argument and sentencing recommendation, please.
Sure. My recommendation is going to be 18 months initial confinement, 1 year extended supervision. So Ms. Stoddy has...
Simply 1 year?
Yes. Ms. Stoddy has a lot of unique characteristics to her that cuts positively and negatively. She doesn't appear to be a person who has much connection to Wisconsin. All of her convictions are in Minnesota. It's the 4 OWIs, it's 2 driving inimical to public safeties. So all of her convictions are driving related, 2 of them not necessarily alcohol related. Even in this case, when she had contact with law enforcement, she said to them, you know, I'm not from Wisconsin, my OWIs are in Minnesota. Ms. Stoddy's OWIs occurred, 2 of them in 2010, 1 in 2011, and then the last one in 2013. So they all appeared within a relatively close range, and the last one was 12 years ago. So she hasn't had an OWI in a very long time, which is why the reason I'm recommending a shorter term of ES than I normally would is because of that, and because she's not a Wisconsin resident. I think she's already done a lot of treatment in Minnesota as well. So I think a lot of what she'll be doing will be refresher, relearning things, repicking up techniques that she didn't apply here. The reason why I'm arguing for the 18 months initial confinement,
The DA nails it Hoy is a crime of risk. You might get lucky and hurt no one until the day you don't. That's why Wisconsin hits repeat offenders hard, even if they didn't crash.
I think the court should go higher because of that gap since the last OWI is so immense. The reason I'm arguing for the 18 months in this case, though, is it can be easy to forget why OWI is a crime and why it has such a high penalty. Because whenever we have an OWI where there's nobody who got hit or killed, we have just the offender. So all the information we're hearing is about rehabilitative potential. And that fixes the focus directly on what benefits them. OWI is a crime. It has such a high penalty because it's a high risk crime. It's a crime of risk. That's why the legislature always changes the reckless driving laws in tandem with the OWI laws, because they're both associated with risk. And it's kind of an oddity, I think, personally, in Wisconsin, that if someone has an OWI 4 or an OWI 5 or 6, we talk about like 1, 2, 3 years prison. When somebody has an OWI 5 or 6 and they hit someone, it goes way higher if they hit someone and kill someone.
269. She knew exactly what she was doing. 5th strike. High risk. What do you think? Viewers? Should the judge stick with a minimum 18 months, or should a fire to change earn some leniency?
It goes higher still because the actual act is the same in all of those. It's the risk. In this case, the risk imposed was pretty high. There are certain blood alcohol concentrations where a person might be, am I intoxicated? Am I just a little buzzed? Am I good to drive? Ms. Stoddy was at a 0.269, which is well beyond that. She clearly knew she was intoxicated. You could tell from the statements to the officers. She was pretty hammered. She knew she shouldn't be driving. She mentioned saying, I'm getting arrested to an OWI before they even really arrested her yet on the phone to a significant other. I fully believe, based on what we've seen from her and what we've heard from the character witness, that she has the fire. She has the desire to change. My concern is with the follow through. That's why I think we need the prison and the ES. Because we've even seen it just in this case with the missed court appearances.